Welcome to Cardamone Law University, translating the Pennsylvania Workers' Compensation Act into plain English for injured
Law
workers.
University.
It's Mike
Translating
Cardamone
the
here,
Pennsylvania Workers' Compensation Act
Pennsylvania Workers'
into plain English for
settlements,
injured workers.
and specifically
It's Mike Cardamone
the
here.
concept of
Today I wanted to talk
timing
about
and when is the
the
best
big
time
picture
to
of
settle a
Pennsylvania workers'
comp
compensation
case.
and how litigation works.
Before we get into some
Litigation
of the
means
details,
that
you
there
want to
was a
remember that
petition
you should get an
filed
attorney
in your case,
on your
either by
side.
your attorney,
And although we say this
yourself
over
if
and
you're
over and
pro
over,
se,
it's just the truth.
or the employer,
You're going to end up
insurance
netting a lot
carrier's
more
attorney.
money, even with the 20% attorney's
So a
fee.
petition may be
The
filed.
statistics are
and
clear
it's filed
on
on
this,
our
so
system called
make
WICAS,
sure you don't do this alone.
AIS.
The insurance company's
Once that
job
petition
is
is
to
filed,
settle
the
every case for as
opponent
little as possible.
will have to
Let
respond
me
to
repeat
it
that
and
because a
file
lot of
what's
people
called
don't
an
understand
answer.
that.
And
Their
normally
job
you'll get a copy of that
is
as
to
well as
settle
a copy
every
of the
case for
original
as little
petition.
as possible.
After that, you'll receive
And
an
commensurate
assignment
with
notice.
that, to pay as little benefits as possible.
The assignment
prior
notice will
to a
tell you who
settlement,
the judge is,
whether
that's
that's
going to be
wage loss
presiding
or
over your
indemnity,
case.
which is wage loss benefits.
That's simply what it tells you.
So you want to keep this in
nothing else.
mind.
After
And
that,
if you
you'll
think you're
receive
going to
hearing
get a good
notice.
result on your own,
And that'll tell
you're
you the
probably
date, time,
mistaken in
and
about
location
99% of the time.
for the
So make sure you
for
get
the
a
first
certified
hearing, and that
workers'
could be a
comp
pre-trial
attorney.
hearing
You can call me
where
anytime you
just
want.
the attorneys are
You don't
speaking
have
with
to
the
pay us
judge
any
about
money out
the
of
issues
your pocket. It's a contingent
and how they're going to
system
present their
in
cases.
Pennsylvania. And I'll remind
Or
you of our
it could
phone
be
number. It's
scheduled for
215
testimony.
206.
It depends on the judge, so you have to look at the hearing notice
9068.
carefully.
It's 215
And your attorney will have access to
206
what's called a judge's questionnaire that we
68.
have on WICAS.
So when is the best
And we can
time
tell,
to settle a case?
we can read
the
what
short
the
answer
particular
is when
judge's
the parties,
style
that
is
is
for
the
the first
claimant
hearing, whether it's a pre-trial for
and
the lawyers
the insurance carrier,
or whether they get
are
right
willing,
into testimony
ready,
from
and
the injured
able
worker.
to settle the case.
Regardless,
In
what
most
will happen at the
instances,
first
that will
hearing
be
also
when the
is
injured
the
worker
judge
has
will
reached what's
tell the
called
parties
MMI,
when the evidence is
or
due.
maximum medical
And
improvement.
let's say you're an injured worker, the judge will tell you
That's
that
a situation
if it's a
where
claim
basically
petition,
your condition has plateaued,
which is filed when your
and the doctor will say
claim
you're
is
not really
denied,
expected to get worse, but
and
you're
you're
probably
seeking
not going to get
benefits.
better. This is
the
something
judge
you
will
have to
tell
live
you
with
you have
and just
90
manage.
days to present your
For example,
case.
if you have a back
Now,
injury,
there can be continuations and some
and you tried
extensions for good
therapy
cause.
and injections, and ultimately
Sometimes
had
we can't get a
surgery,
doctor's
and you
deposition
had
done in a certain
post-surgical
time
physical therapy
because of a conflict in
about
somebody's
9 to 12
calendar,
months
things
after
like that.
surgery,
But
you'll probably
in general,
hit
90
MMI,
days is the
where
rule
you're not
for
gonna really
presentation of your
get
evidence.
any better or any worse at that
What will
point.
that entail?
That would be
On
a
a
good
claim
time to settle
petition,
a
normally
case.
the claimant's
Why?
deposition,
Because you don't have any more surgery
which
on
we'll
the
do
horizon,
pretty soon
presumably.
after the case gets
And
started.
there's not really much else they can do
in
for
addition
you
to a
medically.
doctor's deposition.
And also at that
Usually
point,
the treating
you're probably
doctor,
going to have
the
undergone
one who's
what's
most
called an
familiar with
independent
your
medical
situation.
exam.
And then
So
we'll
the
present
insurance
the injured
company
worker, the
knows what their
claimant,
doctor's
again,
opinions
live
are,
before the judge,
as
the
well
final
as the treating
hearing,
doctor's opinion,
just
with
as an
respect
update
to
from the deposition.
what kind of work
and so the
you
judge can
do.
see the injured worker
So
and make a
that's
credibility
the,
determination
answer
in their
for a
final
lot of
decision.
cases, but not all of them.
Some of the judges will have
Sometimes
serial
a
hearings
client,
every
an injured
90
worker
days.
has
So
to settle a
and,
case
a
early
first
because they're in
hearing,
a financial
and then
predicament.
one 90 days later
And we
for
might
the
tell them,
claimant
hey,
to
the
present
case is
their
worth
evidence,
X amount of dollars,
if in fact it's a
and they might
claim
say,
petition.
listen, I
or a
respect your
penalty.
opinion,
If
but
it's
I need to settle
a
this
petition
case,
filed
and
by the
I'll
other
take even
side,
less. I need to settle it. I'm in a
then
hole,
they would have
or
their 90
I have a
days
problem, or whatever.
starting from the first hearing. And
So
some
sometimes
judges
we
will
have to
just
settle
have
these
an
prematurely,
initial
but
hearing and a final hearing.
Patience pays off, and
So 2 total
you
hearings.
want to really
and
listen
that would be
to
a
your
pre-trial,
attorney.
which was
We get a
would
lot
be
of
the first
calls
hearing,
from injured workers,
and then the
who are being
final
represented
hearing.
by other law firms.
And if there's any
And sometimes
questions or problems, the
it
parties
appears the
can
case is
request
being
a
handled
hearing
just
or
fine.
a conference
And
call
the
with the
injured workers
judge.
just frustrated at the
So the moving party is
that
90
the
days
fact
for their
that their
evidence, and
case
the
is
opponent
worth,
will have 90 days
certain
thereafter.
amount
Not
of dollars
90
or
days
in a
total
certain
for
range,
both parties,
and perhaps
90
they're
days
looking
for
somebody
each
to tell
party.
them what they want to hear.
So there's
And
180
and other
days
times,
right there, which
the
is
firms,
6 months.
They don't
And
have
that's
a
if
good
there's
handle on
no
what they're doing.
extensions or
They might
requests
just be
for
dabbling in
continuance,
workers'
things
comp
like
and not
that.
really handle a lot of cases.
At the first hearing,
we
the
usually
judge will
tell
also
people try
ask
to
the
work it out with
attorneys
their attorney,
whether they want
and if they
mandatory
can't, then they
mediation
can,
scheduled.
hire us.
Normally,
if we're
that
willing
will
to
be
take their
scheduled
case.
unless
So
the parties deem it to be
a
futile.
lot of people get frustrated because
mediation
in workers'
is
comp
where you
you
meet
don't have
with
pain
another
and suffering
judge,
damages.
not the one presiding over
Okay,
your
so
case
it's not
in
a
most cases,
fault-based system
but a
like
different
personal
judge.
injury.
injury.
to try
And
to
as a
settle your
consequence,
case.
it's really
the settlements
we'll talk
are really
about
tied
mediations another
to your
time.
loss
In
of
fact,
earning
I think
power.
we may have already
The future medical,
put out
that has
an
some
episode
value,
about,
but not
about
as much
mediations.
as most
There's
people
two
think.
kinds:
It's
voluntary
really the
and
biggest
mandatory.
component
So if
here
the
is your wage
mandatory
loss check
mediation is deemed
and how much
futile
that is,
at the
and
first
also the
hearing, the
nature of your
parties can always
disability
request
and,
what's called a
how long
voluntary
you're going to be
mediation
projected to
and
be
pick
out
the
of work
judge that
for,
they want,
and what's your
and get a date
residual
scheduled for
earning
that.
capacity.
So
if you made $1,000
hearing,
at the
the
time
judge
of the
will
work
also
injury,
tell the other
but
side,
the insurance company
meaning
has
the
a
employer,
credible
insurance carrier,
vocational opinion
if
that
they're
you
going to
can
get
now
an
earn
independent
$500
medical
a
exam
week,
to have that done or scheduled
and they
within
win
45
a
days,
petition
somewhere
on that
in that
issue,
time
they'll have to
frame.
pay 2/3 of the difference, and so you'll be
And then
down
what happens basically
at a much
is,
lower check, and
if,
that will lower
if that
the
first
settlement
hearing is a
value.
pre-trial, and
So,
there's no
but
testimony
going back
taken,
to the big picture,
we'll schedule claimant's
really,
deposition
in most
pretty
cases,
quickly.
the best time to
get
settle is
that
when the
taken
medical
care of,
treatment is sort of
and then
settled,
if it's our burden,
settled
meaning
down,
our
and there's
petition,
not too much on the horizon.
we'll go
But
ahead
again,
and schedule our medical
there are
evidence.
exceptions, and one
Sometimes
of those
we'll
could
wait
be,
until the
if you're in a
independent
financial
medical exam
predicament
comes
or
back,
something
the
like that.
report
So
from their doctor,
each case
'cause if
is
there's an
unique.
agreement, we can
It's
streamline
just like
things
real
and
estate.
save
Every
$3,000,
every
$4,000,
piece of property is
$5,000
unique.
on a medical
The
deposition.
same thing can be said with a workers'
some judges
comp
are
case,
lenient
and the
with
last
that,
thing you want to do
letting us wait
is
a little
compare
bit.
your case
Other
to a
judges,
neighbor or a friend.
they don't really care. They just want their,
Pardon me, I can't tell you how many
their
times we've
timelines
received
followed. So
phone calls
you
from
kind of have
our
to know the
clients or
judge that you're practicing before to figure
prospective
that
clients
out.
who say, "Well, my friend,
and then the other side
he
will
settled
take
his
their
case for
medical
200,000,
deposition,
and
Usually, the
I have to sort of
independent
cross-examine them and say,
doctor,
well, how much was their
and then,
average weekly wage?
Again, there's
Well,
usually
I
a
don't
final
know.
hearing where the record will close.
What was their nature of their disability?
The
and
evidence will be
diagnosis?
submitted.
I don't know. Do they need surgery?
And
I don't know.
you will write
Who was
down
their
what the
doctor?
exhibits
I
are.
don't know. Who was the
and
IME
make sure
doctor?
they're uploaded
I don't know.
into
Who
our
was the
system
judge
called
presiding
WICUS
over any of their petitions?
for the
I don't
judge.
know.
And what
what's
happens is
their
usually we'll have the
education
claimant
level?
testify,
I don't
as
know.
I said, at that
Has a
final
vocational
listing as an
evaluation been
update
done?
from
I
their
don't know.
deposition.
What about an impairment rating evaluation?
And
so
the
when
judge
you start
will
going
issue
down these
what's called
questions,
a
you realize
briefing
that every
schedule.
case is different.
Briefs
You
are the
cannot
written
compare your
arguments
case to
from the
somebody
attorney
else's
summarizing the law.
Everybody has their own
the facts
factors
of the
involved.
case and why each
So,
side
this is just a
met
brief
their burden of
summary.
proof or didn't
We
meet their
could
burden of
probably
proof.
speak about
And they're
Pennsylvania
pretty
workers'
tedious.
comp
They tend to
settlements
be
for
20 to 40
straight.
pages.
But I just wanted
Because
to
you have
pass
to cite
along
to the
some
record
of
and
the basic
summarize all the
concepts here,
relevant facts and summarize
in terms
the law
of the
and then
timing.
do your analysis
If you have any
and
questions,
arguments.
again, call us
So that can be a tedious process. The judges will normally give
9068, or you can
30
email me
to
directly.
45,
I'm
sometimes
a certified
60
workers'
days
comp specialist
from the final hearing
in Pennsylvania. That's
for the
Michael
attorneys to
at
submit their briefs.
CardamoneLaw.com.
It can take 2 or 3 weeks just to get the transcript back from the court reporter from the final hearing. So that's why the judges allow a couple months sometimes for the written arguments. In addition to the fact that everybody's busy in workers' comp, it's a fairly high volume practice. And so you might have 4 other briefs to write in the next month. And so the judges understand that. They have a lot on their plate too. So these things don't happen at breakneck speed. So from the start to finish with a petition, you're looking at about 1 year until a final decision from the judge. Things can be streamlined. Sometimes things settle. Sometimes you're able to submit what's called a stipulation on some or all the issues and speed things up. Sometimes the cases will settle for what's called a compromise and release. That happens fairly frequently. However, you need to be prepared for the long haul, because if things don't go your way and the case is contentious and fought the entire way, you're looking at about a year until you get that final decision from the judge from the date your petition was filed. Could be a little sooner, could be a little later, but a year would be the average. So you really have to kind of prepare and talk to your attorney about how you're going to survive. If it's a claim petition, which means your workers' comp claim was denied, you're not getting any cash in the meantime. So you have to figure out how you're going to survive during that 1 year that you could be in court for. Is it unemployment comp, short or long-term disability, either severance, pension, Social Security disability, Social Security old age benefits? There's different options that you want to look into and go over with your attorney to figure out, should I apply for them? And if I get them, how will it affect my case and my payout? So I wanted to go over the big picture stuff here, because a lot of times we get bogged down in some of the nitty gritty stuff. And I thought it would be a good time to go over the infrastructure. In other words, how does litigation work in Pennsylvania workers' comp? And If you have any questions about any of this, make sure to call us at 215-206-9068. That's 215-206-9068. That's the number for our firm, Cardamone Law. And you can email me directly. It's michael@cardamonelaw.com. So MICHAEL at CARDAMONELAW.com. Our website is cardamonelaw.com, and we also have a really popular blog at paworkinjury.info. That's paworkinjury.info. That's all for now from Cardamone Law University, and we'll talk to you soon. Thanks.